colleagues, welcome to our session on third-party liability insurance, TPLI. It is for the third year in a row that we have a lot of listeners, a lot of visitors of this session, which is good. Every time we have something new and interesting to discuss. So let me first introduce our panelists, whom you all know very well. Vladimir Tituhin, Deputy Head of the Central Bank. Igor Yurgens, President of Russian Union of Insurance, Russian Union of Auto Insurance, National Union of Liability Insurance. Yuri Voronin, Chief Financial Commissioner for Financial Services Consumers. Marina Pichulina, Deputy Head of Finance Markets, Control Department, Federal Anti-Monopoly Service. Yevgeny Ufimtsev, Executive Director of Russian Union of Motor Users, Insurers. So we know each other very well, but we have had two interesting events that we should discuss. First event is that we moved from words to action as far as tariff formation liberalization is concerned for TPLI and tariff individualization. This has become a very significant step towards my ambition to fully cancel TPLI tariff cancellation. So the bill that we have introduced, it was approved by the Russian government and submitted to the State Duma, and the parliament members promised to discuss it shortly in the first reading. Well, between the first and the second reading, some time may pass. Sometimes it takes 5 years before the second reading takes place. But our goal is to initiate the first reading and then make sure the second reading follows shortly. So the second event is that our financial ombudsman is now working. And as we previously discussed, we're going to have the first public event with your participation, where you can share share the status and we have a feeling that as soon as there is a place for the users to complain, the users will take full advantage of that and will start complaining. They will start saying that the car insurance lawyers are to blame and the government is to blame. So we will see what you have to say today. Yuri Viktorovich is the only one here who can comment on this complaining process and tell us what is going on in real world. I know that you have the slides, so please let us put them on the display. Yes, so the question that you asked, I will answer in the end of my presentation. Let me start by saying that indeed, 1 year ago, at the previous Moscow Financial Forum, I presented our service, which was in the making at that time. And today I can speak about the first steps that we have taken. Yes, we consider different cases. We've been doing this for several months. TPLI cases and other cases, because by jurisdiction, our service is expected to address TPLA cases and other cases. The law will take effect in phases. We'll see how how it's going to work in the future, but let me start with the first slide. This shows the major properties of the new legal institution, the institution of financial representatives. So the idea is to address different cases before putting them to the court, up to for the value for up to 300,000 rubles. So we're talking about the prejudicial settlement, and we would like to take all advantages of this prejudicial settlement and implement them here in this country. Make it available to the public, to the people. So there will be no need to apply to consulting companies, write long applications. So this institution does not involve any judicial actions, and the benefit for the people is that there is no fee for using this service, and the representatives of this institution are supposed to make sure that the rights of the people are not violated. Decisions of our institution are of a recommendation nature. They're not mandatory. But usually ombudsmen work in organizations headed by Igor Yuryevich. But the institution of a financial ombudsman is isolated from all parties of the dispute and from the consumer, and this ensures the objectivity and the unbiased approach to cases of this financial ombudsman. There are similar institutions in other countries, but only in our country this institution commits to addressing the case within 15 days after its filing to our institution. This institution is aimed to encourage a prejudicial settlement of cases, and we're looking forward to it. We hope that the establishment of this organization will encourage people not to go to court, but try to settle a dispute before any judicial procedures without appealing to the court. We want to ensure the system is transparent and predictable, because in court each judge relies on his or her own values and understanding. In our case, it is very different. We apply standard practices, and insurance companies can easily predict what type of a decision the financial ombudsman can take. It will be a good incentive for them not to go to court and try to settle disputes without going to court. Openness, professionalism, quality, these are our principles. So this has been the first results of the operation of this institution. So we've been working for 3 months, and we have received over 24,000 appeals. It's hard to say whether it's a lot or not, but we thought there would be fewer applications. The average value of the claim is around 200,000 rubles. What's important is that applications are filed through personal accounts. So there are more personal accounts than the applications themselves. and the claims are being considered, and we still have capacity to accept more applications and appeals. The users themselves can file complaints if they believe there were violations of the law. So, in other words, most of the applicants are individuals, and there are also organizations to whom such cases have been assigned, and they also become applicants if they are registered as legal entities. And we have 217 of those, and we have sole proprietors. There are 114 sole proprietors. So out of 24,000 applications, we had quite a few rejected applications in the first month. The main reason is in compliance with the precision procedures. So we send them to insurance companies, and then they come back. But these are all growth diseases, child diseases, and I'm sure we'll be able to get rid of them. And the number of procedural rejections will go down over time. As far as the trends are concerned,
well, you can see trends on the screen. If we compare June and July, we see a significant increase of applications and the number of decisions. I spoke about rejections already. The share, 53%, was reduced in July and will be further reduced in the future. As regards financial services, clearly, major requirement has to do with TPLI, 23,256. Others have to do comprehensive insurance, BTPL, and other types. But we refuse because either there's problem with the application or wrong jurisdiction. If we look at the spread, federation regions, you'll see that there are most problems in the south, in Volga region, and central regions. If we look at different subjects of Russian Federation, in the lead are Krasnodarsky Krai, Bashkortostan, and Moscow. So that gives you an impression of how the spread looks from the geographical point of view. If we look at topics, TPLIs are in the lead. Most disagree with the amount of compensation, 38% of the total complaints. The second largest would be rejection, then goes violation of timelines, other reasons, or complaints on low quality of repair, and you see statistics for other types of insurance as well. There are a number of problems. We're currently considering, together with the Supreme Court, which is what financial ombudsmen do. Insurers, of course, would like us to be able to reduce the amount of fault fight or interest in arrears, but we'll look in the first place at whether law was violated or not, whether timelines were violated. But all other matters belong to the competence of court, and this is the basic thinking behind our action. And insurers can always go to court to discuss penalties related problems. Talking about practical question, an important question is whether financial ombudsman can increase the amount of claim. If we talk generally from the philosophical point of view, an ombudsman is an arbitrator that deals with disputes, looks at whether contractual norms and legislation were honored, but also at the same time, unlike a judge, he should protect a weaker party and make sure that his interests are protected. So maybe in the future it would make sense that in cases when consumers are not financially literate enough, for instance, when he makes a mistake, when he forgets to demand penalty, in case an ombudsman sees that there were arrears in payment, should be able to initiate a claim for penalties. But if we were to do it now, we'd break the law, because at the preliminary stage we're not allowed to do so. Preliminary stage is very important because we hope to be able to deal with no disputes at this preliminary pre-trial stage. So we cannot deal with it right now. But as regards the volume, the amount of claim, if an applicant miscalculated a claim, if he was unable to properly assess the claim, so if an ombudsman sees that true damage done was larger than what's in the claim, should be allowed to raise the amount indicated. And Supreme Court is telling us that they would endorse this suggestion. So there are many procedural issues like that we try to deal with. So going back to your question. Oh, by the way, I forgot I wanted to give you statistics that's also very interesting. It's not on the slide, but I'm sure you'll find it curious. In the 3 months, financial ombudsman made 2,300 rulings, substantial rulings, and in 49% of instances, in 1,111 instances, were in favor of consumers. In July, the share of rulings was 50-50 in favor of consumers and insurers. In August, the share of rulings in favor of insurance went a little bit up. But since it's a positive trend, if we look at the court statistics, in over 80% the rulings were in favor of insurers. So this example shows that a financial ombudsman wears two hats, acts in two capacities. So we'll see how it evolves in the future, whether we'll be able to find pre-trial settlement to a larger share of dispute. But to answer an eternal question of whether insurers are evil or people try to fool them, well, there's no answer because it's a philosophical question. So the first 3 months of our work has shown that the simplified procedure is in great demand. The market is very much interested. We see that it does help to protect rights, and I think it holds great potential to come up with a good culture of cooperation between service providers and consumers, and we are there to help along the way, but it's the community of clients and the community of insurers should do the job, establish proper working relations. And my final point I want to make, to add to the discussion, is that there are 3 people on this panel that participated in the discussion that was launched by Tatiana Golikova in relation to medical insurance. One might think that motor vehicle insurance and medical insurance are not related, but they are, because they are important and they are mandatory. Medical insurance is a much more complicated subject because there's a combination of state and private companies, while motor vehicle insurance is more classical, standard product. But I want to mention that discussion because it's relevant. I've been thinking a lot about that. I've been trying to understand change that's been happening as social insurance, commercial insurance systems develop, as we compare the two. In the past, I used to think that commercial companies should not be involved in social insurance, but now I changed my mind, and I'll explain why. The problem is that mandatory insurance, by nature, should be social, in a sense that although it's mandatory, it should take into account existing demand. People are mandated by the state to insure certain risks, and that means that states should regulate tariffs if it mandates insurance. And very often that's the reason of a problem, because insurers, they calculate risks, they set individual standards, but they cannot do so in case of mandatory insurance. So a state should be involved to an extent. So I think we need to find solution to that. Although this insurance is mandatory, you can't set standards, you can't set tariffs bluntly, but you can find a combination. So you need to draw a line between commercial insurance and social insurance. So insurers should be allowed to set individual tariffs to certain types of insurers, both for healthcare insurance and motor vehicle insurance. But as for vulnerable groups of people that are unable to pay proper tariffs, those socially vulnerable groups should be protected by the state, and the state should help people that cannot allow to pay a tariff that's justified. So if this two-tier protection system is introduced, we could achieve our goal to ensure liability in case of a car accident, in case of a health problem, and at the same time protect socially vulnerable groups that must be insured but cannot afford insurance. So I think it's a very good platform to discuss these and other related matters. Thanks again. Not only did you give a brilliant overview of your work, but you've raised the bar very high. We don't have enough time to cover all the important issues you've raised, but once again, you've demonstrated that insurance is an amazing market that raises a whole number of theoretical, philosophical issues, not just who's good and who's bad. We spoke about it in St. Petersburg during the St. Petersburg Forum. We had a very lively discussion on the matter. But I think this discussion will last for many years. With this, I want to give the floor to Igor Jurgens. I gave more time to our first speaker because he was speaking for the first time. But, oh, please, it's always the case. When you deal with insurers, there are always limitations. You need to apply for license. But with all due respect, I will try to stick to the timeline. But I have two questions, two specific questions to ask you. How successful is this new institution, a financial ombudsman? Are they successful in protecting you from your clients and your clients from you? And my second question is, going back to the draft law that's in the pipeline. The first discussion has already taken place, the first reading has taken place, various options were discussed. Do you think it helps deal with the IPLI problem? Well, to answer your first question, yes, Ombudsman is a great step forward. We can just look at the number of complaints that the central bank's receiving. The number dropped by 40%, which speaks volumes. The trend began before the Ombudsman was created, but the trend persists. Secondly, we are members of the advisory board of The management board of the Ombudsman is an institution and swiftly responds to our questions. There are still pending issues such as tariffs, but we decided to postpone it by 3 months, accumulating statistics. So we're going to go back to that in 3 months, and we're going to look at penalties. We're going to look at all the different issues. So I think Ombudsman is a very good institution that's already proven to be very efficient in all jurisdictions. Just 3 days back, we had meetings with our German counterparts, and they spoke how important it is. Today, I spoke with Chinese counterparts, and they reaffirmed this point of view. So it's a tool that's applied universally. We're behind the global community, but it's a very positive change. Before I answer your second question, I want to comment on something Yuri mentioned. He compared medical insurance and motor vehicle insurance. For instance, now we're considering introducing a single comprehensive coverage instrument for motor vehicles. Oh no, please let us not go there. Let us not go there. No, I disagree. I want to make my point. So, if we continue this comparison, mandatory medical insurance is very similar to TPLI, third-party liability, although it's not a third party, but it's the basic, if we look at it from the philosophical point of view, basically it's the same. If the state cannot afford to sponsor all of its commitments, it has to bring on board private sector, and then private sector, based on its considerations, can get on board and try and find synergies. So a link is formed between private sector and public sector. It becomes more civilized, it becomes more comprehensive. So if ever we start talking about pension insurance and the role insurers play in mandatory car insurance, health insurance, investment capital, we could apply the same principle. And I very much like what you said. As regards draft law, which is in the pipeline, there are so many companies that were participating in putting it together. Sponsors received lots of criticism from different groups. We were warned many times. The entire community of insurers were told that, oh, look, you'll wait and see, they'll rip you off, just give them a chance. Immediately the tariff will jump 40%, but this market law. But instead of a 40% increase, we've seen a drop of 6%, so it's cheaper for consumers now. As for second stage, we're moving in the same direction, no one's questioning that. I don't have much time, so I will not analyze draft law. I will just say that it does contain a number of novelties for insurers. For instance, no longer apply criteria, type of engine or region in which a policy is issued. But we understand that as you lift those restrictions, as you take out other limits, we shall see that the tariff should be raised by 1.8 at least. 1.2, which is a threshold, is too little, because we introduce restrictions for the richer ones that have powerful vehicles and those that live in rural areas. And again, these people are richer, so we will not raise tariffs for them sufficiently, and at the same time, insurance will become more expensive for people with smaller cars that live in smaller cities, which are by definition less well off. So there are various international consultancy firms that can do the math for us. This draft law is already operational. We hope that the first reading will happen in September. Consultations are in progress. The deadline for amendment was September 6. We hope discussion will resume in September, but we need to do math properly. If those two coefficients are lifted, we need to see if those two indicators are lifted. We need to see the impact. I want to adjourn with this because Evgeny Efimtsov will definitely have something to add in his presentation. Thank you for your attention.
Thank you. So you have made our discussion even more intellectual. But I did as you instructed me. We thought we could discuss both the full coverage insurance and TPLI together. Once we have touched upon it, please speak about TPLI and hull insurance or full coverage insurance. So you represent an oversight agency. So we agree when we discuss theoretical matters, but you are more into practical matters. So ombudsman and liberalization should make your job easier. The market should seek for this invisible hand and help itself. So this is a kind of extension of the invisible hand in the form of mandatory circulation. We are not talking about judicial decision. It is Damocles' sword that is hovering over us. Crime and punishment principle goes even further once we talk about the ombudsman institution, or once we talk about a fee for consideration of a case. Sometimes oversight agency just sits and listens and doesn't do anything. What do you think will happen when the law we're talking about is adopted? Good afternoon, everyone. Thank you for the invitation to speak here. The Minister of Finance organizes a very good conference, a very good forum here. It's great that we can talk about TPLI. We discussed it 1 year ago, and it's a good time to do that again because we have had quite good results. The number of complaints over insurance have gone down 43% in the past 6 months. And the consumer support group now segregates justified claims from unjustified claims. And I'm sure the number of claims will go down because of that. When we see that the number of complaints is going down, we immediately think about this saying that victory always has a lot of mothers, but a loss is usually an orphan. I would identify 3 major reasons why the number of complaints went down. All of these reasons are important in order to increase the trust of people to the system. Number 1 is the regulation has changed at the level of statutes So in 2018, a lot was done to have the statutes published. They took effect in the beginning of this year. So the extension of the tariff corridor was one of them, one of the statutes. It helped stabilize the situation with TPLI. The second reason is the launch of the Financial Ombudsman operation. There is some initial level of trust, so people believed in the simple and easy-to-use system. So the users are looking forward to further using the system. They believe that their requests, their claims can be considered easier without going to court, without going to long judicial procedures. Also, the operation of insurance companies has improved. They started paying more attention to behavioral aspects. Back in 2013, 14, and 15, dialogues with insurance companies were more about financial stability. Starting from 2016, the focus shifted to behavior, to the quality of services provided to the users. That means that insurance companies has walked a long way as compared to their initial position. It helped claims not to be brought to court, not to be brought to the institution of the financial ombudsman, but to consider a case with the insurance companies, at the level of insurance companies. Competition among insurance companies has increased, and that also makes companies more attentive to users' requests. They have huge potential of improving their operation, their interaction with their clients, with the insurers, and we keep pushing them as well. There are no unknown companies at the TPLI market today. There are over 60 of those insurance companies, and they fully understand the TPLI market, how to operate on them. They understand users, clients very well. When we encounter bad situations, these are usually situations taking place in regions, and the application of wrong practices. But all in all, the insurers community takes a very good effort to improve interaction with the public. But there are still a lot of problems remaining. So our bill, our draft law of the Ministry of Finance and the Central Bank is aimed to create tools to address TPLI issues. TPLI should address three things, three fundamental things. Number one, additional protection of the user's rights. For instance, going up from 500,000 to 2 million for health and life insurance. This is for the benefit of the public, of the users, of the consumers. Number two is individualized tariffs. This is a very user-friendly step. We've mentioned it a lot. We want each consumer pay for himself or herself. So the inherent threat that he has with his or her vehicle, this risk should not be shifted from a bad driver to a good driver. And number three thing that the draft law addresses is competitive market of TPLI. Competition improves the product, improves the product quality, and this is what we see happening today. competition is ongoing. Some ratios which turned out to be impractical, they have been cancelled. So pricing has improved to avoid excessive losses. I'm also looking forward to this draft law to be adopted in the first reading quite quickly. And it will require a lot of public discussion before the second reading of this draft law, because not all of the suggestions and proposals made at the early stages of discussion late last year and early this year have been addressed. There have been very good suggestions that need to be discussed to understand whether they should be introduced into the law. I would like to support Mr. Jurgens. By the second reading, we should understand the configuration of the new TPLI law. When we have this understanding, we will be able to perform good appraisal, to understand the tariffs, and to understand who is going to pay and how much. Thank you for keeping the time schedule. I remember us being at some conference. It was back in 2013, if I'm not mistaken, when there was no understanding with the insurers community. There was even a scandal. I have a feeling that the situation has improved. We sit here saying good words to each other. So we have learned to interact. So the regulators say good words about the insurance and vice versa. What we would like to see is consumers saying good words about us. That's right. And now I would like to give the floor to Marina Vladimirovna. The Federal Anti-Monopoly Service is supposed to protect consumers from collusion. As Adam Smith said, the author of The Invisible Hand, in his book, he also wrote about the following situation. If marketplace meet behind closed doors, it's not to improve the product, but to make a collusion against consumers. So these are certainly jokes, but the more we liberalize the tariff, the more flexibility we have in defining that tariff, the more room for competition, and this is what we see happening. But at present, there is not much flexibility yet, and all we do is to individualize the tariff to avoid the uniformity of the tariff. So we want to have a balance of tariffs for good drivers and for bad drivers, appropriate tariffs. So the driver who survived basically used to pay for the one who was killed in a car accident. So the older tariffs did not account for the level of risk inherent in each driver. We did apply certain ratios, but they were not quite accurate. As we use new tariffs, the price of insurance will go down 3 to 4 times for some consumers, for some drivers. If our tariffs are competition-based and market-based, this is why we wanted you, as a representative of the Federal Anti-Monopoly Service, to take part in this discussion. I know you have slides and you have the presentation, so would you please share them with us? Yeah, I would like to use my slides first. Yes, the TPLI reform is in full swing, and it is premature to speak about the results. But what the other panelists have mentioned, the number of complaints coming to this headquarters of the Federal Anti-Monopoly Service has gone down significantly. As far as violation of competences of anti-monopoly bodies are concerned, we also see them going down. The number of violations is going down. We're talking about acknowledged violations which were established as a result of consideration of cases. There is the warning institution, which helps insurance companies adjust their behavior before a lawsuit is filed into court and improve business practices. As far as violations on the insurance market are concerned, in the past year, those violations have been related to unfair competition, and most of them come from unfair competition at the procurement phase. As far as the reform is concerned, early this year, we supported the draft law stipulating changes into the TPLI law. It was about changes in the pricing of TPLI contracts. We do support new tariffs based on the car engine horsepower and the regions. So in combination with the tariff corridor and rights of insurance to use their own approach to tariffs within given limits regulated by the central bank, will help insurers manage their costs and reduce the number of accidents on the road. A few words about the concept of changing TPLI. We've mentioned it many times at different platforms. We believe this concept is still very relevant. So the whole idea is to transition from insurance of a car owner to the driver himself, who may incur damage or injuries, cause damages or injuries. So our proposal is to introduce two ratios that will define the tariff. This approach will help address a number of issues. There will be a need to make a contract for the driver only, regardless of how many cars the individual may own. Then there will be no need to avoid excessive procedures. Tariffication will simplify, and accident-free driving will bring the tariffs down. Also, representation of insurance in TPLI. Well, as far as the representatives are concerned, so the whole idea was was outlined so we're going to revise Law 88, and the representative of the insurer will be a separate department of the insurance company with certain responsibilities and certain authority. For quite some time, we have been observing this market of representatives, and we do have some concerns. What we see is that the situation is not so good. So we performed a study which identified that the number of companies who can act as representatives has gone down 3 times, although the number of cases has increased 3 to 4 times, and this has occurred in the past several years. Therefore, we are in a situation when demand for services goes down, the number of companies who can render such services goes down, and the current law does not set forth the possibility of expanding the number of such companies. Also, the representative contract is voluntary. So we see a trend when there is no obligation to make such a representative contract, and there are not enough companies to do this. This may lead to a situation when only a narrow circle of insurance can perform functions of a representative,
which in our view can reduce competition, can boost prices up, and many would just refuse to enter into contracts. As we did research, we saw that representatives of insurers community supported the idea to authorize more people to act as representatives. In conclusion, we think we need to continue working in this direction and amend law on TPLI, compile a list of organizations that can act as representatives, authorize them to collect data, perform expert analysis, and repair motor vehicles, and authorize the insurers to do additional assessment, take decisions on payments and compensations, etc. Liability will rest with insurer, and citizens will have more opportunities, so it will improve the situation for customers. To answer your question, I want to say that we support individual tariffs, and our proposals are aimed in introducing them at the same time. We think insurers at this point in time should be restricted and act within the price corridor that was set up by the Bank of Russia. So you think we need to limit insurers? Well, they should be allowed to set individual tariffs, but within the corridor that was set forth by the Bank of Russia. So you mean they should not go below the threshold? Because, you know, a corridor has 2 thresholds. Well, thanks for that. I was rather joking, but I will ask colleagues to comment on a couple of points you made, and I have something to say myself. But when I said that the reduction can be 3- to 4-fold. Well, of course, it was an exception. We did find this one instance that was exceptionally low. But I want to stress it for the media specifically, for them not to write that we anticipate a 3-fold or 4-fold reduction of tariff. But general people, we think, will win. An average person, 50 years of age, 30 years of driving experience, can count on a reduction of up to 1,000, up to 2,000. There won't be that many such people, but if we look at this perfect, theoretical perfect driver, we can think of one. So being attentive on roads, being a good driver can help you save. But I have a question. Marina, we had a discussion with your entity, and the government supported us and our position that a shift towards registering insurance of people, not cars, but it is a good idea in theory, but this would mean that prices will go up for most families. Because in most families, there's one car per family, and they can buy one insurance for the motor vehicle and save money. People that own many cars, a car per person, most of them live within the very central part of the city of Moscow. So if you're 3 people, you would have to drive in one car, you would have to buy 3 insurance policies. And for most Russians, that would be an excessive financial burden. But if you remember, we used to have a very lively discussion within the Commission. The thinking, the rationale was that although you buy an insurance policy per vehicle, it should be somehow linked to experience, driving experience of people that will be operating this vehicle. But if we think theoretically what a car is something very dangerous. And if I let a friend who's drunk drive my car, I should also be responsible for a potential car accident, just as if I were to lend my gun to a drunken friend. So I think if you give your car to someone, and if this someone commits a car accident, you should also be held responsible, and your next insurance policy should be more expensive. So I don't think this draft law will worsen the situation for most Russians. And secondly, we think that since cars are dangerous, car owners should be responsible, even if they are not behind wheel during a specific car accident. As regards your other suggestions, talking about intermediaries with a separate draft law that has gone through first reading already, intermediaries in digital, it's part of the digital economy project that covers most points you raised. So we're now preparing for the second reading. Maybe some amendments are indeed needed, we could discuss it, but generally it regulates relations and it deals with at least part of uncertainty about responsibility. So a contract is signed with the insurance company that gets the money, and an intermediary can do paperwork, but the insurer will bear all responsibility. So his role would be technical, and I would like to ask Vladimir to comment about regulation, about technical examination. Did we talk about technical examination? I missed it. So talking about settlement and representatives, my personal attitude is that it's very difficult. TPLI is rather comprehensive, covering most issues, and any company that sells an insurance policy should cover for all the damage done in the territory of the Russian Federation. So an insurance company must have representatives in regions. So imagine a company that understands that it's selling a policy to a citizen that is likely to travel around Russia. So it should understand very clearly that it will have to take care of all damages. So it can create a network of authorized representatives, and it will act responsibly. But we can think of other examples, companies that would say, nah, I just want to sell, and I don't care. Let's mandate insurers from other regions to deal with problems of my clients should they have problems in those respective regions. I don't think that's going to be operational. First, the price will go up. Second, some insurers, for instance, can just refuse to participate in this system for various reasons. So, to answer that question, maybe a social component could help. Maybe a state could intervene. But otherwise, I strongly doubt that would fly, because if you operate in one or two regions, I don't know what you can do. You can tell your clients, I only cover your risks in those two regions. But that's also very theoretical. As for technical examination, of course, it's hard to track this question, how it landed with us at all. I think it was part of the attempt to decriminalize police, but I think it's just too ambitious. It's too demanding. The quality that's demanding is too high. For the union of insurers to be able to handle this huge amount of work, all the checks and inspections, that would require amazing amount of resources, huge budget, which we lack. I think it's up to the state to do that. Insurers community will not be able to meet this challenge. Well, discussion is still in progress. We'll find solution. But yeah, I think it's the level of a state agency, not an association of private companies. Well, that was so comforting. I got distracted. Evgeny Vladimirovich, you wanted to talk about technological breakthroughs. So let's go down to earth and speak about something very specific. I want to hear from someone who has his hands on the wheel, if I may, who works directly with TPLI. Well, I want to start by thanking the Ministry of Finance, the Bank of Russia, for the enormous work they did. They managed to kickstart liberalization, because for years, I remember hearing that the market is about to be liberalized, but nothing happened. That was before crisis, where there were fewer complaints and more clients. But then in 2015, 2016, a crisis began. We've seen a tidal wave of fraud, and many insurers were going out of business, and we're told, no reform is possible, no free tariff is possible. But now the situation is much better. A lot has been done to reduce the number of complaints, to streamline our procedures, to work with specific problems of our clients. An ombudsman was created as an institution. So groundwork has been late to liberalize tariff. Secondly, any free tariff would mean there would be a corridor, a maximum minimum threshold, there will be risks attached, opportunities attached. Insurers have already been able to come up with a system of redistribution of risks, which I think is operational, because often we hear that people fear that once we introduce free tariff, many people would not be able to afford it. But a few years back, 10% of clients were unable to afford an insurance policy, but now the situation is a lot better. There are indeed some clients that cannot afford tariffs lower as they are today, but a system was put in place for them, and as of April 1, they can select from a number of insurers, and more people use it, the system. Now, so more than one insurer now receives state support, the insurance of socially vulnerable groups of people. So now there's a choice of more than one. Oh yeah, I wanted to comment on something Marina mentioned. The market, if you look at the situation the past 5 years, there's no risk anyone would dominate because there are many players on the market. There's no one single player. There's a lot of competition. I fully agree with that. There's a lot of competition right now, and the moment is just right to move the draft law forward because there's competition, there's balanced market, the system of guarantees that allows us to be actively present in that segment. Second, a lot has been done in regions. To give credit where credit is due, some regions were very successful, others were not, to tell the truth. There are still regions where insurers struggle, though they are making a lot of effort to counter fraud, but there are very positive examples, such as Tatarstan. Just many months back, insurers would flee Tatarstan, but now they're in the green zone and they sell insurance policies, grow in volumes. So I think regions are ready for reform, and many regional authorities given special importance to TPLIs. In 2014, 2015, we started changing base rates, raising limits. 3 important changes were introduced this year, laying groundwork for the future reform, which I endorse. As regards changes of insurance premium, we've seen market response. In the past 7 months, the average amount of premium has dropped. Experienced drivers, people with good track record, managed to reduce their payments. Younger, more reckless drivers now pay more. Out of 82 regions, in 60 the average premium either remained unchanged or dropped, and only 20 regions witnessed an increase. Average premium on TPLI. We support the draft law that was introduced. We think it's timely. I think it's a good text. We need to move forward. It changes two ratios, two multipliers, and introduces new criteria that influence tariff. Insurers very much welcome this draft law, but I want to stress one shouldn't fear individual tariffs, because at the moment the maximum multiplier is 2.1 per region and 1.6 per type of engine. So a maximum price of a policy would be a little over 20,000, but you really have to be a bad driver for that, while very many people would save. So the maximum increase would be 1.82. So a rather expensive policy would now cost 15 to 16,000. Although, if you're a reckless driver, yeah, then they sure can apply a higher multiplier. It could relate to taxi drivers, for instance, that tend to be reckless. So I think it would make a lot of sense to allow insurers raise individual tariffs for bad reckless drivers. But by doing so, will not punish good, careful drivers. And I want to mention something that was neglected for some reason, an initiative that you supported is shifting to digital, developing an app, which is work in progress as of October 1st. It will become much easier to get payment. Now, you can file claims for up to 400,000. You can register your application online through this special app. Another important step is that we will be launching November 1st TPLI helper application, and through that, drivers in case of accidents will be able to sign protocols electronically, and it will make their lives much more easier. So we talk about reform of TPLI. It will facilitate administrative procedures for all consumers. So this fall, a lot will change.
I thought you would speak about that, but could you please put it in simple terms? Starting the 1st of October, November, the 1st of November, which applications should consumers use and how? So from your slides, I see that you have postponed this date a little bit. So once again, say it, how they should use it, how they should behave. So starting the 1st of November, for 4 regions of Russia, being Moscow region, St. Petersburg, and St. Petersburg region, consumers can download Помощник ОСАГО application. Consumers, in case of a car accident, receive the insurance coverage up to 400,000 rubles by only using their tablet or smartphone. So the minimum information is required in this application because all the data is in our own database. So the user only needs to verify that his information is in the system and check the box agree. The application will also explain which steps the user should take. The Bank of Russia tested this application, so it takes about 15 minutes to fill out a form and to check the boxes, to fill out the protocol. After completing this protocol, the consumer puts his electronic signature under it. If the other car accident participant is ready to complete this form on that electronic device, he can do it, or he can do it through his own device. So damages can be regulated electronically without any paperwork. but payment of damages is done with the hard copy application. So the user should come to the insurance company and bring a hard copy of the application. Yes, indeed, but in the future we would like to improve the mobile application to have electronic applications in and avoid any paperwork. What if a car accident participants disagree? What should they do? Yes, in case of disagreement, through the application and car accident Euro protocol, it will be possible to settle damages in each region of Russia, even if the participants of a car accident disagree over the size of the damages. In case of disagreement, the insurance company will take care of that, and we see that each month we see more and more people using this mobile application for arguable cases and for cases where the value of damages exceeds 400,000 rubles. So, starting November the 1st, electronic notification will take effect. But if there is no disagreement over the size of damages, it is possible to settle damages ranging from the value of 100,000 to 400,000. If there is disagreement, it is also possible to settle damages for the value up to 100,000 rubles. Помощник ОСАГО application will be operable only in 4 regions of Russia, which I mentioned. But when you say region, it means that an accident takes place in one of those 4 regions, not where the car is registered. This is right. Good. We've been looking forward to it, and we hope it will be effective. So for further questions, you can approach our panelists offline. We had one more disproportion on the market. So the limit amount of damages to be reimbursed in case of a lethal case was 2 million rubles. At the same time, there is one segment which is not insured, and I'm talking about taxi passengers. So we do have a draft law. It was denied. Now there is another draft law. Can anyone comment on it? Yes, we have experts among our listeners who can comment on. Svetlana Gusar, Russian Union of Insurance, of car insurance. Well, as a community, we keep asking to include taxi on the list of vehicles to be insured. At present, taxi passengers are discriminated against the passengers of public transport. So in case of an accident, the passenger of a public transport is at a benefit. So we have taken part in the preparation of the draft law, and the draft law was adopted in the first reading in October last year. Ever since, we haven't seen any developments due to the fact that the Transport Ministry Committee wanted to convince us that the draft law should not be adopted in the second reading, because we're now waiting for the adoption of the law on taxis. Well, this law on taxi is not being adopted. Therefore, taxi passengers are not yet covered. sometimes a passenger or taxi drivers cannot be reimbursed under the TPLI contract. TPLI limit increase will kind of cover this situation, but what we would like to see is to have taxes be included into the TPLI system and law. Yes, I fully agree with your intentions and ambitions, but it is yet unclear what should be done. How to regulate taxi aggregators, and why would we discriminate taxis ordered through a mobile application against taxis ordered offline. So there are still a lot of open questions. This would be a teaser for future discussion, I would say. So what I'm trying to say is that we will certainly come back to this audience. We will be able to discuss progress of those issues that we have outlined and touched upon. We have a couple of more minutes for questions. Please. Please introduce yourself. Elena Alexandrova, SoGas company. My question is about interaction with the financial ombudsman institution. We do not want to appeal the decisions of the financial ombudsman, but as far as the punitive damages are concerned, their size is questionable. We know that such cases were taken to the court, the damages would be much lower. As we interact with the financial ombudsman, it is impossible to argue against the size of punitive damages. So the first answer is simple. Do not incur punitive damages. So pay on time and you will have no problems. The second question is why we cannot decrease the amount of damages. If we do this, we will then affect the operation of the financial ombudsman institution in a bad way. So what we're now working on, together with the Supreme Court, we work on issues related to prejudicial settlement. We are involved in this process. We discussed it at the Council of Experts session. So procedure-wise, we are trying to develop a certain approach on how to appeal and argue against the damages assigned by the financial ombudsman, without arguing against the decision of the ombudsman itself, and only talking about the values. So hopefully this approach will be further developed and finalized, and we take part in this discussion and initiative. So the document, the legislation is not in place, but there is a number of solutions that could address this matter. I'm from Rosgorstrach. Here's my question. I agree that we should avoid punitive damages, but we would also like to avoid execution sheets. And this is how the insurer behaves. So the court rules against the insurance company for the company to pay damages to an individual. So we do it as an insurance company, but the consumer doesn't submit the appropriate paperwork. But he does it several months later, and we then incur interest of 1% per day from the value of the damages. There is the letter of the central bank, or instruction of the central bank to other banks, giving them 6 days to confirm that the paperwork submitted by the consumer is authentic. So we should probably work through the central bank or with the central bank to make the life of insurance companies easier. Just one word. It's a good question. The fact that the current model of operation of the financial ombudsman is not ideal. It prompted certain violations. One way is to change the model itself. Maybe we will work together with the Supreme Court, as was mentioned, and we should make our own suggestions as well. Yes, but I agree, yes, we should pay damages on time. But when you learn about the fact that you need to pay damages 3 months after the accident, then it's another matter. We can certainly say that if the paperwork is submitted not on time, then no damages will be paid. Well, this may not be a very good idea, not be very practical. But any law, any regulation, any statute is written on the basis of legitimate behavior and lawful behavior of individuals and entities. What you describe is a violation of the law. As Mikhail Fedotov used to say, he chairs the Presidential Council, and for me, he was a professor at the university. He had a certain principle saying, so if the situation is illegal, you cannot find a legal way out of it. So if we operate with the law, we cannot find a way from an unlawful situation. But if we see that there are so many violations and cases that you describe, then we need to look at the law and find and eliminate the deficiencies of the law. Well, a reasonable person wouldn't wait for 3 months to be paid damages. He or she would certainly go and submit the application on time. And it would be more than natural just to assign certain time limits. If there is a gross delay, then the insurer should be relieved from paying the damages. This is not so difficult. Let's make amendments, draft amendments to the law and consider them. It's like with lottery tickets. If the winner doesn't come for his or her money within a certain period of time, the money will not be paid to him or her in the end. So I think we have covered our agenda, and we do not have any more time. but the moderator always has this preemptive right to extend the discussion. Well, I took advantage of my right several times already. Well, I hope to see you all next year at the Moscow Financial Forum again.